Reno is here. Correct. Okay, we're on the record in the matter of the people of the state of Michigan versus Bradley Scott Miles, file number 23-02630, and then people of the state of Michigan versus Aiden Wilson, file number 23-02629. Counsel appearances.
Your Honor, thank you and good morning. Assistant Prosecutor Bill Crino on behalf of the people of the state of Michigan.
Your Honor, good morning. My name is Keith Watson. I appear today on behalf of Aiden Wilson. He appears remotely from the Dane County Jail via Zoom.
Good morning, Your Honor. Lionel Woolley on behalf of Mr. Bradley Bernard Stuttmiles, who are both appearing via Zoom this morning.
Today was the date and the time that was originally set for a preliminary examination. Last week at the time of the probable cause conference, the parties indicated that they wanted to stipulate to have this matter transferred to Judge Flores' docket because he does have a related case already pending there. We can do that. We just need a stipulation on the record and a waiver of the 21 days. There's the prosecution stipulating to have that or have these matters transferred to Judge Flores' docket.
Your Honor, yes, we are stipulating that both of these cases be transferred to Judge Flores' docket. There is a pending homicide case involving both of these defendants, which is scheduled for preliminary examination on October 24th. So it would be our intention that these cases be joined with those cases for a joint single preliminary examination. So we are so stipulating. Additionally, for the record, Your Honor, the people would be waiving our right on both of the cases here today to preliminary examination within 21 days.
Okay, thank you. Mr. Woolley.
That is correct, Your Honor. Last week when we were there, we did agree to adjourn this matter, waive 21 days. So on the record today, we are prepared and ready to waive the 21 days to hold the examination. Ask the court to transfer the matter to Judge Flores, or an earlier case is already in front of that judge. Thank you.
You and Mr. Watson.
Your Honor, on behalf of Mr. Wilson, it's true that when we discovered that the second case had come to Your Honor, that probably the most effective way for us to handle these both, because they involve similar witnesses and many of the same witnesses, is for this second case that came before Your Honor, we transferred to Judge Flores so that both matters could be handled there. And it's for those reasons and for reasons that have been placed on the record by my distinguished colleagues that we would as well agree to the waiver of the 21 days. I asked Your Honor to inquire of my client, actually of both of these defendants, so that there can be no question about this.
Thank you. Aiden Wilson.
Yes.
Okay, you're scheduled today to have a preliminary examination. You have the right to have preliminary examination in this file within 21 days of your arraignment. But due to the fact that this is a co-defendant case and there's another related matter already pending before Judge Flores, are you willing to waive the 21-day timeline so this matter can be reset before Judge Flores?
Yes, ma'am.
Okay, anybody threatening you to get you to waive the 21-day timeline?
Oh,
Okay, was there any promises made to you in exchange for you waiving the timeline? Can you repeat that?
no.
Okay, thank you. And then Mr. Stuttmiles, can you hear me?
Yes, ma'am.
Likewise for you, you have the right to have a preliminary examination in this matter within 21 days of your arraignment. Your matter was scheduled to have an examination today, but due to the pending matter already before Judge Flores, which is related to this case, would you be willing to waive the 21-day timeline so this case can be transferred to Judge Flores' docket?
Yes, ma'am.
Anybody threatening you to get you to waive the timeline?
No, ma'am.
Has there been any promises made to you in exchange for a waiver of the timeline?
No, ma'am.
Okay. I'll note that there's been a waiver on the record of both files for 21 days. These matters will be transferred to Judge Flores' docket to coordinate with the timeline of the other pending matter that's set for October 21st. Any additional matters for today?
Your Honor, thank you. Nothing for the people.
Nothing on behalf of Mr. Wilson, thank you.
Thank you, Bond, and each matter will continue. Mr. Woolley?
Further on the defense side for Mr. Stottmiles, Your Honor. Thank you.
Thank you. You're all set.
Thank you, Your Honor.
Mr. Stottmiles and Mr. Wilson, you're all set for today.
Yes, ma'am.
Mr. Woolley's back. Who's on the blue Studio Mini? What's your name?
Brandon Williams.
Okay, Mr. Williams is present, okay. And then who's in the, oh, it's Darion. Darion Summerall, yeah. Okay. Sounds good. Okay. Did Mr. Williams get an attorney? Mr. Berry, are you here for Mr. Williams?
I am here.
Okay. On the record in the matter of the people of the state of Michigan versus Brandon Williams, file number 23-02812, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Ronald Berry, appearing on behalf of Brandon Williams, who appears to be joining us today.
Okay, Mr. Williams, today was the date that was originally scheduled for your preliminary examination, but due to the need for conflict counsel to be appointed, I did advise you last week that we would treat today as another probable cause conference. I do have a substitution of attorney here, substituting Mr. Ron Berry in for the Office of the Public Defender to represent you. And so, let me see, I don't think I waived the timeline last week, but we obviously need to address the timeline today. Due to the conflict, I'm gonna go ahead and find good cause to go beyond the 21 days. And then we can get you a new probable cause conference if necessary, and then exam date. Do you need another probable cause conference?
Yes, Your Honor.
Okay, and so you're clear, Mr. Williams, you did have the right to have your preliminary examination within 21 days of the date of your arraignment, but again, there was an issue needing or requiring you to have conflict counsel appointed. So the court's gonna find good cause to go beyond that 21 days, so we can set this up for a new date now that you have new counsel, okay?
Yes, Your Honor.
October 13th at 1:30. Does October 13th at 1:30 work for you?
It does, Your Honor.
October 19th at 9:30. October 19th at 9:30 work for you?
Sorry, Your Honor, I'm having to put them
For
on.
October 19th.
October 19th, at what time?
9:30. At 9:30.
I'll make that work, Your Honor.
Be heavy on that. Oh, okay, sounds good. Okay. Bond in this matter was set at 2,000 personal recognizance. Bond will continue. Any additional matters for today's record?
Nothing from the people, Your Honor.
Well, Your Honor, given the fact that I was just appointed yesterday and the only contact information from Mr. Williams that I received from the Public Defender's Office is his email, if I could just have Mr. Williams provide me his phone number real quick.
Mr. Williams, can you give us your phone number?
Yes, Your Honor. 517-512-8183.
Did you say 3183?
8183.
8183.
8183. Okay, Mr. Williams, I sent you an email yesterday to your williambrandon842@gmail.com. Please check that and reply, and then I'll be giving you a call here in a little bit to the phone number you just provided, okay?
Okay.
Thank you. Thank you, Your Honor.
Thank you. You're all set, Mr. Williams. We're on the record in the matter of the people of the state of Michigan versus Ricardo Eddington, file number 23-02343. Oh, I don't see Mr. Austin.
Eddington.
Oh, okay, Mr. Abbott.
Mr. Austin is in trial, Your Honor.
Okay, sounds good. Council appearance?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott, representing Mr. Bennington.
Okay, Mr. Eddington, how are you?
How are you?
I'm doing well. My understanding is that the people are unable to proceed today, which is the time set for your preliminary examination because the necessary witnesses failed to appear. They are making a motion to move to have this nolly without prejudice. Any objection to that?
No, thank you.
Okay, we'll sign it and get it to you. Without prejudice simply means they have the right to reissue the charge against you, okay? Do you have any questions at this time? Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
Thank you, you're all set. Is Ms. Donnelly representing Mr. King or is someone filling in? Oh, okay, fine, this is Mr. King. Is Solace in person? Yes. Who's this in the jail? Good morning. Is Mr. Goodrich here? Gotta let him know. Let Mr. Goodrich know Mr. Polito is on. Are we running King?
So I think we're gonna ask for an adjournment to send him to mental health court.
We're on the record in the matter of the people of the state of Michigan versus Trevor Anthony King, file number 23-02465. Here for the record.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson. I think on behalf of Trevor King. I think I'm standing in for another attorney. I know Mr. Watson had asked me to stand in for someone else in the office.
Donnelly.
Just Donnelly.
Okay, so today is the date and the time that was set for a preliminary examination. We've already addressed the timeline previously. This was originally scheduled in August. And you wanted an adjournment so that he could be screened for mental health court?
That's correct, Your Honor.
Let me get you 30 days.
That's it.
I was requesting 30 days.
Yeah, that sounds about, that's what I was gonna ask for, Judge.
November 9th at 9:30. November 9th at 9:30. Did you,
Donnelly will make that work, Your Honor.
okay, did you have anything that you wanted to share? Or I didn't know if you had something that you were going to say.
No, Your Honor.
Oh, okay. sounds good.
In person?
If we're not running an examination, you don't need to appear in person. You only need to appear in person if we're gonna run an exam. Okay, correct. You check with your attorney before that date so we know how we're proceeding, okay?
All right.
Okay. Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor.
You're all set. We'll get you a notice, okay? Have a good one. I'm sorry. I told him we'll give him a notice, but I think he just maybe stepped out. I'm not sure.
I'm sorry, Your Honor. It disconnected. I think the Zoom malfunctioned on my end.
What's your name?
Brandon Williams.
Mr. Williams, you were all set. Did you get your next court date?
I did not receive the email, Your Honor.
There was no email. We told you the date on the record. You didn't hear us?
I apologize, though I didn't, Your Honor.
What was the date?
October 13th at 1:30.
You're gonna have a probable cause conference October 13th at 1:30. And your
Okay.
preliminary examination will be October 19th
Okay,
at
thank you.
9:30 in the morning in person at the court, okay?
Okay, thank you, Your Honor.
You're welcome, sir. Okay, let me see here.
Let me see if they.
Mr. Starks is here for the competency.
Percy Harrison, Your Honor, yes.
On the record, can we remove him, please? In the matter of the people of the state of Michigan versus Percy Harrison, file number 22-01722 FY. Counsel appearance.
Jeff Bradowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Jacob Starks, fourth assistant public defender, here appearing on behalf of Percy Harrison Jr. Mr. Harrison is currently at a facility under the care of a CFP, Your Honor. But I will waive his appearance this morning. I understand there was going to be some transportation issues or some other scheduling problems on CFP's end, but I'm ready to proceed. And I will waive his appearance. Thank you.
We did attempt to make arrangements to have them maybe put him on virtually or have him appear, and I think they couldn't do it until next week. Nonetheless, we do have a report here from the State of Michigan Department of Health and Human Services Center for Forensic Psychiatry, dated for September 25th, 2023. Did each of you get a copy of this report?
Yes, I did, Your Honor.
Yes, Your Honor.
Okay. And the conclusion of the report is that it is the opinion of the examiner at this time that Mr. Harrison does now have the capacity to understand the nature and the object of his proceedings and is competent to stand trial. Is there any reason to have objections to the body or the conclusion of the report?
Nothing from the people, Your Honor.
No, Your Honor. Defense will stipulate the findings and the conclusions of the report, Your Honor. We just request that this matter be set for preliminary examination. Thank you.
The court will adopt the report and the conclusion and incorporate it as part of the court file, and we'll get you a new, do you need a new probable cause conference?
Your Honor, I believe we can just resolve this either if we can work out a plea, we can take care of that.
We'll
I don't
get you an
think we need
exam
a
date. Okay.
separate, yeah, probable cause conference for it, Your Honor. Thank you.
November 16th at 10:30. Does that work?
Thank you, Your Honor. Yes.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the bench, Your Honor. Thank you.
Thank you. You're all set. Okay, well, we'll wait for just a moment. That one. I thought I just seen Mr. Goodrich. I did. For Polito. Mr. Goodrich, did you need to speak with Polito at all?
I've already spoken.
Silas is downstairs. Okay, we running Silas?
That's Mr. Pfeiffer's. I'm not sure what's going on with that.
Okay, on the record, in the matter of the people of the state of Michigan versus Clemente Polito Jr., file number 23-01911, counsel appearance.
Jeff Bradowitz on behalf of the people, Your Honor.
Luke Goodrich from the Public Defender's Office, here to represent Mr. Polito, who's appearing from the jail. This is currently not Mr. Polito on the screen.
I don't know why it's highlighting him. Mr. Polito, can you hear us?
Yes.
Okay, Mr. Polito, today's the date and the time that's set for a sentencing. I do have a pre-sentence report. It was prepared on August 25th, 2023. Mr. Goodrich, did you get a copy of that?
Yes, I did, Your Honor.
We need to make updates, corrections, or deletions.
The only update I would ask for is that he has been in custody for 101 days as of today.
Okay, I'll note that update. Any other updates?
No other updates or corrections.
Okay, you can make allocution.
Thank you, Your Honor. Your Honor, I know probation actually recommended probation in this case. However, after meeting with Mr. Polito, he would like to ask the court for a jail sentence in this case. He started working with cats at the jail a month or two ago at this point, and he goes to substance abuse and anger management classes through them, and he's found them very helpful. And he said in the past, when he's done probation, he always has trouble making it to appointments and getting transportation here. And he's saying here, he's forced to do it. He's there every week. It's helpful. He has a good relationship with the people who are doing the counseling there. Your Honor, he's had no contact violations at all. I haven't heard of any issues with Mr. Polito since he's been in the jail. So based on that, we would just ask the court to give him a jail sentence in this matter, allow him to continue his essentially classes and such while in jail.
And did your client wish to make his own statement?
Mr. Polito, did you want to make your own statement?
No, I'm okay.
Okay, well, I reviewed the pre-sentence report and the recommendation, which was for a term of 365 days jail credit time served and suspend the balance upon successful completion of a term of probation. They were recommending 14 months probation, which is pretty extensive. I've also reviewed Mr. Polito's prior criminal history, which there are multiple prior convictions that were assaultive in nature. I'm happy to hear that he's found some programming while in custody that he's benefiting from. And with that being stated, I'm not going to dispute his request to fulfill his need to continue that treatment. I am going to go ahead and sentence him to 365 days Ingham County Jail credit time served, and he'll be ordered to continue his treatment and classes while in the custody of the Ingham County Jail. Do you have any questions at this time, sir?
When I get out, I'll be able to go straight home then, Your Honor?
When you're released, you're able to go home, yes.
Okay, thank you.
No problem. Any additional matters for the record, counsel?
No, Your Honor.
Nothing from the people, Your Honor.
You're all set, sir. Thank you.
Thank you, Your Honor.
You're welcome. You're free to go, Mr. Polito.
Okay, thank you.
You're welcome. Who's someone? That was Mr. Feigelson, correct? Are you gonna cover for Ms. Donnelly on that?
Which one?
Someone?
Suppose I can.
I'm not sure. It's my note says we're treating it as another probable cause conference. But
Somerville's here.
Samarar, he's on the screen. Did you need to speak to him?
I probably should, Your Honor. I'll go.
Okay.
I get the Zoom code real quick. What's going on? Thanks.
No problem. Did we see Jafari Watson today?
Yes.
Okay, Jafari Watson is here. Salish is in custody. We're running Watson.
That I would need to speak, just briefly with, Mr. Palmer, Your Honor, to see what he plans to do on that one this morning. It would be my intention to run it victimless. However, I'm not sure how he wants to proceed, so.
I know I see Mr. Doyle. It's his client here.
I believe he's meeting, with her at the moment. I think he took an advice of rights, and we do have a plea sheet on that one, Your Honor.
Okay, Thibodeau is in custody. Is she downstairs or they gonna put her on? Okay, and then we're running Leonard.
I believe that is the case, Your Honor. That would be Ms. Delvero's case.
Okay, and what about Schmidt? We're running that.
That is, it was the prosecution's intention to at least begin that one, as the victim is a minor in that one. However, in speaking with defense counsel, Mr. Zaney, I know he planned to ask for an adjournment for some additional discovery he was seeking.
Who's the prosecutor on that? You?
That would be me.
On the record in the matter of the people of the state of Michigan versus Frank William Schmidt, file number 23-02825, counsel appearance.
Jeff Rado, on behalf of the people, Your Honor.
Edward Zaney, on behalf of the defendant, he's present to my right, Your Honor, Mr. Schmidt.
Okay, how are you both?
Well, Your Honor, how are you this morning?
I'm doing well. Today was the date set for preliminary examination, and Mr. Zaney, you need additional discovery.
Correct, Your Honor. We're doing some independent investigation. I submitted some several FOIAs as well as a private investigator. So I think I'm asking the court for 30 days approximately to be able to appropriately prepare. If the court needs it sooner, I can do 2 weeks. But I'm
What I need, believe me.
30 days would be appropriate, please. And
I don't
thank you,
gotta
Your Honor.
review the discovery, you do. Okay, and did you talk to your client about his right to have an exam within 21 days of his arraignment?
I did, Your Honor. He's prepared to waive the right to have the exam within 21 days of his arraignment.
You've already made your request, or you're planning to make your request
I
for
made my request formally before the court.
for additional discovery, I mean, did you?
Oh, this is independent discovery that they want to.
Oh, got it.
necessarily
Sounds
have.
good.
This decided to go to third parties.
Gotcha. Okay, so, Mr. Schmidt, you understand that you have the right to have a preliminary examination within 21 days of the date of your arraignment? Okay, and due to the additional discovery that your attorney is doing to help formulate your defense, are you willing to waive the timeline so I can reset this?
Yes, ma'am.
Okay, anybody threatening you to do that? Any force or any promise being made to get you to do that? Okay, we'll get you a new date.
Thank you, Your Honor.
For 17, does that work?
What is it?
November 17th?
Yes, I have a wonderful suit on for the court.
Thank you.
Yes, ma'am.
November 17th at what time?
9:30.
At 9:30.
Yes, ma'am. We'll have one.
Not today.
I think today's just okay. It's kind of,
It's raining.
it's right, exactly. I was just gonna say the weather, Judge, you know, that's our.
Okay, any additional matters for the record today?
Nothing from the people, Your Honor.
Thank you, Your Honor.
Bond will continue. You're all set.
Have a wonderful week.
Thank you.
Same to you.
Now let me know.
Thank you.
Okay, we're on the record in the matter of the people of the state of Michigan versus Darion Summerer, file number 23-02789. Council appearance.
Jeff Brotto, it's on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Summerall, Your Honor, who's present from the Young County Jail. I'm standing in for Ms. Donnelly, who's in another matter this morning. She apologizes for her absence.
No worries. I did have a note that we were going to treat today as another probable cause conference because the parties were trying to factor a global resolution for this, because he has a matter in Mason.
That's correct.
Yes, Your Honor.
We're still doing that?
Yes, Your Honor, at this time, after conversations with the Public Defender's Office and with my office, I believe we have effectuated a potential global resolution in this matter. However, due to Ms. Donnelly not being here and different conversations with different members of the Public Defender's Office, when Mr. Feigelson met with Mr. Summerhour recently, he was unaware of the offer. He has since been made aware of the potential global resolution. And so I think the plan at this point is to ask, it would just be to leave this set for a preliminary examination with the understanding that that offer is on the table and will, at least seems acceptable. That offer, just for the record, would be for Mr. Summerhour to plea to count 2 in this matter, which would be domestic violence second offense notice, with the condition that he entered DV court. And as the victims on this one are the same as the victims on the case in 55th, there would be an agreement to the restitution on the case out in 55th District Court on this file, at which point the people would dismiss the case out in the 55th District Court.
Okay, he's already deemed eligible for the justice.
That would be something that I would need to look into over this week, Your Honor, as well as getting the exact restitution amount. But I believe that can all be settled within this week prior to an exam set next week.
Okay, Mr. Summerall, did you hear everything that was stated there?
Yes, ma'am.
And you understand what's going on?
Yes, ma'am.
Okay, so you had the right to have a preliminary examination in this matter within 21 days of the date that you were arraigned. So your examination was scheduled for today, but due to working through the global resolution, are you willing to waive the timeline for the examination so I can reset this matter?
Yes, ma'am. So you said I'll have 21 days for them to schedule another court date?
No, what I was saying is that you were arraigned on September 10th and you had the right to have your preliminary examination within 21 days of that date. That's what I was saying.
Okay. Yes, Your Honor, I understand.
So are you understand that now, sir?
Yes, ma'am.
Okay, and so because you're working with your attorney and the prosecutor's office to try to put together a global resolution of your pending matters, are you willing to waive the 21-day timeline and I'll reset this for another court date?
Yes, ma'am.
Is anybody threatening you to get you to waive the timeline?
No, ma'am.
Any promises being made to you if you waive it?
No, ma'am.
November 9th at 9.
November 9th at 9 a.m. is the new date. Any additional matters for today's record?
Nothing from the people.
I'd like to address bond if I may, Your Honor. Mr. Summerall can live with his grandmother, which is not anywhere near the alleged victims in this case, Your Honor. He is young outside of these 2 pending matters. I believe he has no other pending matters, Your Honor. I'd ask for a PR bond this morning.
Mr. Barrett.
1 second, Your Honor, to see. I don't believe we did a bond form in this matter.
I'm sorry?
I don't believe we did a bond form in this matter, but let me just double check. Yes, the people did file a bond form in this matter, Your Honor. The people would stand by that bond form.
Do you have multiple warrants that at the time of the arrest were addressed? Because other matters other than the one in Mason pending?
I'm not sure, Mr. Summerall, do you have other matters pending elsewhere?
I think those are child support.
Just child support, which was released today, I believe. Oh, and the driving while license suspended.
According to the records that I have, there is some indication that he has a prior history of failing to appear in court. And then obviously there's an allegation of multiple assaults on the same victim. So there is a concern about the threat of the safety of that victim. I think they also have a child in common. Bond was set at 20,000, 10%. It says 10% cash surety though, so I don't know what that means. Let me see here. What did they put it in? Is it cash surety or 10%? Because they wrote both. Okay. Bond was set as at 20,000, 10%. Personal recognizance bond will not be granted. I'll adjust the bond to 10,000, 10% with GPS tether and victim notification. All other bond conditions, including the no contact order with Alyssa Sharp, will continue. You're not to have contact directly or indirectly with Alyssa Sharp. You're not to be within 2,000 feet of wherever Alyssa Sharp is. Do you understand that?
Yes, ma'am.
Where does your grandmother live?
806 Armstrong Road, Lansing, Michigan.
Okay. What's your phone number?
517-612-5600.
Any additional matters for the record today?
None, Your Honor, thank you.
Nothing from the people, Your Honor.
You're all set. Thank you. You're all set, sir.
All right. Thank you, Your Honor.
Okay. On the record in the matter, the people of the state of Michigan versus Shaniqua Parker, file number 23-02121FY. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. May I please court Dan Dorpan on behalf of Ms. Parker, who is present and standing in the court to my right.
How are you, Ms. Parker? Thank you. Okay. Today was the date and the time that was set for preliminary examination. I have an offer from the people. They are offering for you to plead guilty to an added count 2 of disturbing the peace. And in exchange, you need to surrender the taser. This is not this disturbing the peace civil infraction, correct?
No, it would not be, Your Honor. It would be the 90-day.
Okay. There is a kilibrew of fines and costs only. So that's a complete and accurate understanding of the plea offer.
It is, Your Honor.
Okay, and you want to accept that offer, ma'am?
Yeah.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Thank you. You can put your hand down. You have an advice of rights with today's date on it, and that's your signature, ma'am? Did you read this document?
Yes.
And did you discuss these rights with your attorney?
Yes.
And you understand that you have to give up all of these rights in order to accept this offer? Are you willing to do that?
Yes.
Okay, so you have the right to have a trial in this matter. You have the right to a jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at a trial. You understand that right?
Yes.
You willing to give up those rights?
Yes.
Are you willing to give up the right to see, hear, or question or cross-examine any other witnesses that they intended to call against you at a trial? You're willing to give up the right to call your own witnesses or present evidence at trial that you believe further a defense to the charge being brought against you?
Yes.
And you also have the right to remain silent at trial and not have silence be used against you. You want to give that up? Is that right? The right to remain silent?
Yes.
Okay. Okay. Anybody threatening you to do that?
No.
You sure?
Yes.
Okay. Any promises being made to you?
No.
Are you entering a guilty plea to disturbing the peace because you believe you're guilty?
Yes.
Okay. As to the amended charge or the added count 2 of disturbing the peace, how do you plead?
Guilty.
Okay, right. Well, you have to ask yourself. You can't ask him.
No, I'm, okay, guilty.
Okay.
I'm pleading guilty to disturbing the peace.
Okay, and you're not on probation
No,
or at this time, okay, or parole?
no.
Okay, and then there's a kilibrew. That's an agreement between you and the prosecutor. I'm not a party to that, okay? So if I decide I'm gonna do a sentencing other than fines and costs, I can give you the opportunity to withdraw your plea, okay?
Okay.
And you also understand that with this plea, you need to surrender the device, which is a taser?
Yes.
Okay, factual basis?
Yes, Your Honor, I was gonna ask my client factual basis regarding the original count.
Okay.
Ms. Parker, on or about July 9th, 2023, were you at the location of 1000 East Mountain Hope Ave?
Yes.
That's in the city of Lansing, Union County?
Yes, correct.
And at that location, did you possess a taser?
Yes, I did.
And you didn't have at that time a CPL that would allow you to possess a taser?
No, I did not.
And I believe that's complete and accurate for the factual basis, Your Honor.
Any questions from Mr. Brodowitz?
Nothing from the people, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. He's already have the taser in custody or in their possession.
I believe so, Your Honor. Yeah. Yeah, and Mr. Doyle's informing me that they kept it, and I believe from the police report they did have it, so.
Okay. Make allocution.
Yes, Your Honor, my client fully accepts responsibility of her actions. She's employed as a home health care agent. I would just ask Your Honor to abide by the Kyoto Agreement and allow her 30 days to pay the.
I've got a couple of payment plans, I think, going already, correct? Did you make your payment that you were supposed to make last time?
Yes, I did.
When are you making your next payment?
Said it was on the 19th, but I'm gonna try to do it on the 13th. I get paid Friday the 13th. and Also Friday the 6th, but I want to go with the 13th.
Okay, well, your fine on this one is $150. You can make payment on this once you're caught up on the other, okay? And how long do you think it's gonna take you to pay off the others?
Not that long.
30 days?
Yeah, I was gonna say 4 weeks, yeah.
Okay. Well, I'll give you 60 days to pay this.
Okay.
And you know how to make a payment, but if you have any questions, you can ask at this time. If you have questions?
No.
Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. Thank you, ma'am.
Thank you.
On my back, signature form.
You taking a picture of the exhibit?
Yep. Partly because I think it's funny, and partly because I'm gonna need to have that at a moment's notice, probably, that format.
Mr. Joe Martinez, that was,
Oh,
he
yes.
created that.
Joel's the best.
He was great. Went out a week in advance.
Yep.
This Joe is held out in family.
Wow.
And so the first day I moved to town, I lived in my apartment complex.
Okay, Mr. Ferguson, you have Mr. Perales?
Yes, ma'am.
Are we running that?
We're gonna wait, I'm just waiting for him to be brought up.
Okay, we can bring him up. And then who else are we ready on? Mr. Who's on Salas?
That would be Mr. Pfeiffer. I believe I'm not.
Are we running Salas? I don't know.
Your Honor, I'm still waiting for Mr. Freeman to come back up. I believe he's still talking with his client. I don't believe we'll be running that exam today. I think it's gonna be either a waiver or an adjournment for
Oh,
a variety of
timeline.
lovely reasons.
He's in Judge Buchanan right now.
3 minutes?
No, I
Yes.
was in Buchanan.
He's got it.
Don't tell me Joko. Huh? It's probably Joko.
A lot of things.
Okay, let's see. Who are we running? We gotta get some action going.
Possibly, I believe Leonard will be running, Your Honor.
Well, let's get it popping. We're ready to go.
The Veras here, and then I need to speak with Mr. Palmer about Mr. Are you ready on that?
record in the matter of the people of the state of Michigan versus John Cleo Leonard, file number 23-01093 FY. Council appearance.
Good morning, Your Honor. Angela Del Vero on behalf of the people.
And good morning, Your Honor. Dustin Coons for John Khalil Leonard, who's here to my right.
Okay, today was the date set for a preliminary examination and we're not going to proceed, is that correct?
That's accurate, Your Honor. The people would at this time move for dismissal without prejudice.
There's obviously no objection to that.
No objection.
Okay, so without prejudice means that they have the right to reissue the charge against you. You understand that?
Yes, ma'am.
Do you have any questions? Okay, we're going to get you a copy of the dismissal in just a moment, okay? You can have a seat. Thank you.
You running or are you done?
Possibly.
On the record in the matter of the people of the state of Michigan versus Andrew Perales Jr., file number 23-02417 FY, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, or good morning, Your Honor. Assistant Public Defender Stephen Feigelson, attorney on behalf of Mr. Perales Jr. for today's exam.
Okay, Mr. Perales, today's the date that's set for a preliminary examination. My understanding is that there's an unconditional waiver of the examination. Is that correct?
Yes, Your Honor. At this time, I believe the parties have agreed to unconditionally waive the right to hold an exam today, and the people would move that it be found over to the circuit court as charged.
That's correct, Your Honor. We wish to waive the exam this morning.
Was there an offer on this?
There was not an offer, Your Honor. Negotiations would continue in circuit court.
That's correct, Your Honor.
Okay, Mr. Perales, you understand your right to have a preliminary examination in a district court?
Yes, Your Honor.
Okay, you understand the purpose is to require the prosecution to meet their burden, which is probable cause. So they need to establish that they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. You understand that?
Yes, Your Honor.
You're willing to waive your examination unconditionally today?
Yes, Your Honor.
You understand that that waiver cannot be retracted. So once this matter is found over, you can't later determine that you want to have your exam. You understand that?
Yes, Your Honor.
And that's your signature?
Yes, it is, Your Honor.
Anybody threatening you to waive your exam?
No, Your Honor.
Any promises being made to you to get you to waive your exam?
No, Your Honor.
So you're waiving it freely and voluntarily?
Yes, Your Honor.
Okay, and find the matter over to the circuit court for a bind over date of October 11th. That's the date they'll get the file from this court, not a date that you need to appear in court, okay?
Yes, okay, Your Honor.
Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that date, okay?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Okay, any additional matters?
Yes, Your Honor, may I address bond?
Yes.
I believe Bond Presley is sending a cash surety bond, Your Honor, today. I know we were in front of court last week and Mr. Perales asked for a PR bond, and we made that request. We did have a few other matters in front of Judge Ward this week that did get taken, well, not taken care of, but didn't get PR bonds on those matters. And I think he had other outstanding matters with the city of Lansing that got taken care of as well this week in this court. I know he has a pending matter in front of Judge Flores next week, but I asked for a PR bond on this case this morning. I'd like to believe that that case will prepare itself next week.
Sounds good. Mr. Brodowitz?
The people would, at least in regards to this case, Your Honor, the people would leave it to the court's discretion.
Okay, bond will be amended to 3,000 personal recognizance. All other bond conditions will continue. Any additional matters for today?
None, Your Honor.
Mr. Brodowitz, anything else?
Sorry, nothing from the people, Your Honor.
Nothing on behalf of the defense.
Thank you, you're all set.
Thank you, Your Honor. Have a great day.
You too.
3,000, Your Honor.
3,000, yep, that was cash surety, I guess
Yeah.
amended. Are we running, Mr. Palmer, are we running?
We are not running, Judge. This is going to be a request for adjournment.
On the record, in the matter of the people of the state of Michigan versus Defari Watson, file number 23-02756. Appearance, please.
Jeff Brodowitz on behalf of the people, Your Honor.
And thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Watson, the gentleman who stated my rights.
Okay, Mr. Watson, today is the date that's set for a preliminary examination. Why are we not proceeding today?
Thank you, Judge. Based on some new information that I've received today, we are going to request an adjournment. The offer at this time is to have an adjournment done so that Mr. Watson can be screened for domestic violence court with Judge Ward. Mr. Watson has this file pending. He also has another file, which I can pull up if the court needs the court number, but I believe he has another misdemeanor domestic violence that's pending before this court. The idea is that we will have him screened for domestic violence court, potentially resolve both of his pending files at this time.
That's accurate.
Yes, Your Honor. The new information, the people did find some jail calls that were either made or attempted between the defendant, Mr. Watson, and the complaining victim in this matter. We have made Mr. Palmer aware of those. At this time, based on the defendant's willingness to take the offer made by the people would not seek to proceed on those jail calls and would not seek to proceed on any bond violations made up to today's date, which would be September 28th, 2023, Your Honor.
It's an allegation of bond violation, which is contempt of court.
Judge, just to be clear, I was handed this and I'm not, to be clear, I think they just discovered it. So it's not like there was some secret that was kept from me. I'm not suggesting that. The only thing I guess I'd have to look into, they've advised me, they've already looked at it. He was given a PR bond after his arraignment. I think all of these calls came the day of his arraignment. I think at least the allegation is that at least one of them came after the arraignment, it sounds like.
He posted a bond.
Or I'm sorry, he posted a bond. I must have mistaken that, Judge. But the issue there is that obviously until he's arraigned, there's not a no contact order until he's arraigned. So I think there could be potentially a question. We'll look into it. Nonetheless, we are asking that because I'm just advised of this morning, I don't have a great way to defend that. We'll certainly look into that, but nonetheless, we are renewing our request for an adjournment so that we can have this.
Okay, did you advise your client of his right to have an examination within 21 days?
I did, Your Honor, and he's prepared to waive, at this time, to waive his right to not to have the examination, but to certainly adjourn it so that he can be screened.
Okay, Mr. Watson, you understand that you have the right to have a preliminary examination within 21 days of your arraignment date?
Yes, Your Honor.
Okay, and because you're seeking to be screened for participation in the domestic violence specialty court, are you willing to waive the timeline so that we can reset this?
Yes, ma'am.
Anybody threatening you to get you to waive the timeline?
No.
Any promises being made to you?
No, Your Honor.
Okay.
October 19th.
I'm sorry?
October 19th at 9.
October 19th at 9. 9 a.m. That works for you, Mr. Palmer?
Yes.
Well, Mr. Palmer,
Sorry.
that works for Mr. Palmer, you saying?
No, I thought you were gonna say my name. I'm sorry.
Oh, no. We're trying to coordinate with his court schedule.
That should work, Judge.
Okay. Any additional matters, Mr. Days, record?
Just so it's on the record, Your Honor, I know that last time there was an individual in this court that was screened for DV court. Judge Ward did plea in her court, but I believe failed to notify your staff. I will make sure that if Judge Ward wishes to do the plea, that your staff is notified and the proper paperwork can be done to effectuate that.
Sounds good. Any additional matters for you, counsel?
I don't believe I have anything additional, Judge. Thank you.
Okay, bond will continue as well as the no contact order. You're all set.
Thank you, Judge.
Thank you. And there was, Thibodeau was supposed to be treated like a PCC.
Yes, I believe she's appearing from jail.
I never
I'm
put
not
her
sure if
on.
they put her on yet.
No.
I believe it was going to be just a 21-day waiver so that she can be screened for mental health court.
She's already waited 21 days. This was original. She was arraigned.
Oh, that's right. This is an older case.
Wait, when was she arraigned? Maybe I made that up.
No,
she
this
did.
case is from
July.
Yeah.
She failed to appear. So she's gonna be screened?
Yes,
What?
she'll be in conversation with Mr. Etheridge. She wishes to be screened for mental health court.
Okay, can I have 30 days?
I think that should be sufficient.
Watson got adjourned to October 19th. Does he need to wait 30 days? Yeah.
She's being screened, so probably not. We'll be here on November 9th then at 9:30. November 9th at 9:30. Why, what's going on November 9th? I just don't want to ask too many people. Oh, yeah, it sounds like she's gonna be screened. Let's see, Solace.
I believe Mr. Pfeiffer's still waiting on Mr. Freeman.
So that's
I'm gonna
Mr.
go.
Pfeiffer's too. You're running that, Mr. Pfeiffer?
No, but I still need.
Yeah, I'll.
No exams today, huh? Nobody wants to run.
Thanks.
That's the last case I got. Nobody wants to run an exam today.
court with the court's consent. And next court hearing will wait for 21 days.
Tiffany already waived the 21 days.
I mean, you already determined. This
Yeah,
court-
she didn't appear after her arraignment for exam, so that was back in like July or something. So we gave you a new date. What's the new date for her? I think it is November 9th.
November 9th?
November 9th.
Yeah, 9:30.
All right, I'll make the referral and talk to you. Yeah.
Are you ready to proceed? Are you
Yes,
ready?
Your Honor.
Okay. On the record, in the matter of the people of the state of Michigan versus Bradley Salas, file number 23-02750, counsel appearance.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender on behalf of defendants.
Today is the date that was set for preliminary examination for Mr. Salas. But my understanding is that we're not planning to proceed today. Is that correct?
That's correct, Your Honor. The people will be requesting an adjournment today for many reasons. First and foremost of which is that starting 2 days ago on the 26th, he has been calling the victim in this matter. He was sending her e-messages starting the 23rd. I have copies of them here if the court would like, but I turned them over to defense counsel yesterday when I located them. The victim then gives him a number to call, and he has been calling that number. He actually called her 5 times yesterday after I spoke with defense counsel. And that's not to say defense counsel didn't warn him. I don't believe defense counsel told him about these until this morning, but just said to give you a time frame here. In 2 days, he's called her 14 times and told her things like, when he gets out, we're going to get married, you know, don't ever do this again. I love you so much. Also, if she comes to court, I'm going to be serving 15 years in the state or in federal prison. And getting a message through to her not to come to court. As a result of that, Your Honor, an adjournment is needed because while normally I proceed under 27C if I do not have the victim here, in this case, there's a late report, I'd be unable to, but the people seeking move forward under forfeiture by wrongdoing because the defendant took steps to make sure she wouldn't come to court and testify. Further, I was informed this morning by Officer Armstrong that the phone dump of the defendant's phone has been completed. He had it on the original USB working copy of it. So they are in the process of getting that formally over to our office and admitted as evidence. And while he has not taken a deep dive into it, he did tell me from what he saw, he did see threatening messages, which go to the heart of one of the charges, that being aggravated stalking. As a result of the defendant's continued contacts with the victim and the new evidence that has been finally processed, an adjournment is necessary, Your Honor.
Counsel?
Thank you very much, Your Honor. The three of us know that Mr. Salas is entitled to preliminary examination within 21 days of his arraignment. If counsel is asking for an adjournment that is within those 21 days, I'd be hard pressed to object. My client being incarcerated notwithstanding. On the other hand, if the purpose of delay is to continue investigation in order to see whether there is enough evidence to charge my client with additional offenses, I think that there are other ways to handle that. If the 21 days expires, I would, of course, be remiss if I did not move the court to dismiss the case and allow the prosecutor to reissue with all these new charges that he's alluding to. On the other hand, we three know that we start with the rule that motions by the prosecutor to amend this complaint should be liberally granted, and that's true. That's true. On the other hand, those motions to amend typically come during an examination when a witness testifies to something beyond what was known to either counsel or law enforcement at the time. That's usually how that goes. So if the people want an adjournment in order to collect additional evidence and bring additional charges, that's his prerogative. If the case is set within the 21 days, I would have no objection.
Thank you.
Yeah, I'd be asking good cause be found because the defendant made new evidence Tuesday.
Good cause is supported by the allegations put on the record that the defendant is allegedly violating his bond conditions by making unauthorized contact with the protected party, and time is needed so that the prosecution office can further investigate those claims. And as alleged, some of the evidence would include information or evidence that may be beneficial in the underlying matter, in addition to potential new charges being granted. So good cause will be found. I'll grant the request for the adjournment. I'm also going to suspend the defendant's phone privileges while in the Ingham County Jail pending a hearing.
I'd also ask that include e-message and video visits. He was also talking about trying to set up video visits with him.
I'll grant the request to add email and video visits. Those will be suspended pending a hearing on a potential bond violation. So the allegations that have been brought forth today, sir, is that you violated your bond conditions, which is a contempt of court, because you were arraigned on this matter. In the arraignment, you were told you're not to have contact directly or indirectly with the Shamila Bradley, and that you were not to make contact with her or through a third party. You're not to even be within 2,000 feet of wherever she is. And so the allegations would be that you violated that. You would have a right to have a contested hearing on the violation allegations. And if you're found to be in violation of your bond conditions, your bond can be revoked. You're currently on or have a 150,000 cash surety bond. You could have your bond revoked, not that you posted it, or you could be sentenced to a contempt of court penalty, 93 days in jail, and or up to $7,500 in fines for a bond violation. You understand that?
Yes, Your Honor.
Okay. As to the allegation that you taken some steps which would constitute a bond violation, we'll enter a not guilty plea at this time. We're going to reset this matter and as well as the examination. November 17th. November 17th at 9.
People should be free.
Judge, I'm sorry, it's me, not you. I didn't catch the date.
November 17th at 9 a.m.
Thank you very much.
No problem. Any additional matters for the record?
Not from the people, Your Honor.
Nothing from the defense at this time. Thank you, Judge.
Thank you. You're all set.
You said 9 a.m.?
9 a.m. Yeah.
Perfect. Thank you. I tried to put it in for the wrong time.